As part of our U.S. immigration learning series, today we will talk about the USCIS 240-day rule for United States immigration. The 240-day rule is a USCIS guideline for certain non-immigrant work visa holders to continue working in the United States after the expiration of the authorized period of stay. In this video, we will understand what is the 240-day rule. Who does the 240-day rule apply to? How does it impact your U.S. immigration journey if rule is broken? And what is the answer to related frequently asked questions?
Visit our Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
Now, let's get into the video and try to understand the topic in details. Let's first understand, what is the 240-day rule? To work in the United States temporarily as a lawful non-immigrant, temporary workers must obtain respective U.S. work visa based on their planned employment purpose. Upon admission to the United States, U.S. Customs and Border Protection, CBP, issues an online Form I-94 or arrival departure record showing the date of admission, class of admission, and admitted until date. The admission stamp in your travel document or the I-94 or I-94 West shows your non-immigrant status and the length of time you can legally remain in the United States. Please note that the admission stamp in your travel document or the I-94, I-94 West shows how long you are permitted to remain in the United States, not your non-immigrant visa. A visa only shows when and how many times you may seek admission to the United States from abroad based on the classification noted on your visa. But if you wish to remain in the United States longer than you originally planned, USCIS allows you apply for an extension of your stay in the United States to continue the same activities permitted when you were first admitted to this country. As per USCIS Employee Handbook, employers or work visa sponsoring companies can file extensions for their employees using I-129 form before their I-94 expires. USCIS processing times for your visa petitions can sometimes get very long, and some visa holders may end up in situations where their I-94 expires. While USCIS is processing such petitions, the employees with pending visa extension petitions are authorized to work for up to 240 days or until USCIS denies visa extension petitions, whichever comes early. That means, if USCIS denies your extension petition earlier than 240 days mark, from the day your previous petition or I-94 expired, then you need to stop working immediately and leave the country. To avoid confusions, let's see, when does 240-day calculation start? The official regulation for 240-day rule is published in Federal Register says that a non-immigrant work visa with pending extension petition can work for up to 240 days from the date of expiration of authorized status, which is basically the expiration date of your I-94 form or previously approved I-797 notice. So, are there any conditions required to take advantage of 240-day rule? Yes, there are the required conditions for non-immigrant visa holders to take advantage of 240-day rule. Such as, applicant has to be in valid status while filing extension petition. Applicant must continue to work for the same employer, sponsor who has filed extension. Employer, sponsor has to file extension petition well in advance, and USCIS has to receive the same on time before expiration of status. Now, let's understand. If extension petition denied after 240 days, are you in unlawful presence? If your extension gets denied after 240 days, essentially your stay becomes unauthorized. You are essentially out of status and will accrue unlawful presence from the day of your denial. Your unlawful presence starts from the day of your denial decision from USCIS and will accrue from that day. You must need to leave United States immediately after your denial decision is notified to you. So, what if someone doesn't leave the United States after the extension is denied? While it is important to always maintain your non-immigrant status while in the U.S., but if someone accrue more than 180 days but less than 1 year of unlawful presence will be barred from re-entry to the United States for 3 years. If someone accrue for 1 year or more beyond the period of authorized stay, the person will be barred from re-entering the United States for 10 years. Now at last, let's check some of the frequently asked questions and their answers. Number 1. What non-immigrant visa holders can use 240-day rule? The 240-day rule can be leveraged for most of work visas such as H1B, H1B1, H2A, H2B, H3, L1, O1, O2, P1, P2, P3, R1, TN, A3, E1, E2, E3, G equals 5, CW1 and I number 2. Does 240-day rule apply for H1B, L1 transfer? No, the 240 days rule does not apply for any transfer petitions. Number 3. Does 240-day rule applies to extension plus amendments petitions? Ideally, the 240-day rule is applied to extensions only and amendment is added part of extension petition. You should be eligible to continue working even after 240 days. But we recommend to check with your employer or sponsor also.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!